All right, Corinna, go for it.
Welcome to everyone joining us today, this Thursday, January 20th. I want to thank the co-conveners of this event, the Sabin Center for Climate Change Law at Columbia Law School, the Promise Institute at UCLA School of Law, and the Wildlife Justice Commission. I want to thank our distinguished speakers and to everyone who made time to be with us today. We are really pleased to be joined by people from various parts of the world, and want to note that the chat is open and we will be posting some links in there, including full biographies of our three main speakers when I introduce them each in turn. After we hear from our speakers and we have some dialogue within the panel, we will also be taking questions from the audience. And we ask that if you have a question, please post it in the Q&A rather than the chat. We plan to end the program at 1:30 p.m. Eastern time. I know you all are in other time zones, in an hour and a half. But before we get started with all that, I am so happy that Reverend Fred Davie of Union will say a few words of welcome. And also that Professor Michael Berger of Columbia Law School will say some words of introduction. So first, Reverend Davie, he served as Executive Vice President of Union Theological Seminary during the time of the founding and the formative years of the Center for Earth Ethics, and has been one of our most important advisors and supporters. He also does courageous and effective work on local, national, and global human rights issues, and he currently serves on the U.S. Commission on International Religious Freedom. Fred.
Thank you, Corinna. And on behalf of Union Theological Seminary and our president, the Reverend Dr. Serene Jones, I want to welcome you all to this event. Union has a legacy of convening and guiding public issues of grave moral importance globally, from Professor Reinhold Niebuhr's ethical arguments for American intervention in World War II, to Union Seminary's invitation to the Reverend Dr. Martin Luther King Jr. to give his historic Beyond Vietnam speech that was held at our neighboring Riverside Church, to the global forum we just held a few months ago about international human rights for LGBTQIA persons and faith as an official side event to President Biden's Summit for Democracy, and so much more. But there is no more important issue than our global environment. It is connected to every major social justice issue we care deeply about. And we are proud the Center for Earth Ethics works hard on this issue every day from their home base right here at Union Seminary. I want to extend a word of welcome to you all, invite you to join us back at Union for our other gatherings, and then now turn it back over to the Executive Director of the Center for Earth Ethics, Corinna Gore, who is a graduate of Union. We're so proud to be able to claim her as one of our own, and Columbia Law School. She's a good friend and a close colleague, and she will moderate the panel today. So Corinna, back to you. Thank you.
Thank you so much. Really appreciate that. And now, Professor Michael Berger is the Executive Director of the Sabin Center for Climate Change Law at Columbia Law School, which is a phenomenal team of attorneys who are dedicated to understanding and engaging with legal strategies to combat climate change, and also educating others on how to do so. We are so happy to work with him and to hear his thoughts now on this topic and forum. Mike.
Okay. My internet is giving me a whole lot of trouble right now.
Well, one thing we could do is I could give my framing remarks and then go back to you right afterwards before we turn to the panelists. Maybe allow you a moment to troubleshoot. Speak now if you object. Okay, great. So we'll hopefully hear back from Professor Berger in a moment. So the relationship between ethics and law has been at the crux of all major breakthroughs for justice. Ethics deals, do you want to go, Mike? Are you okay?
Am I back? Am I live?
Yes, you're back.
Okay. I apologize. My internet here in Brooklyn, New York, for some reason is wonky as hell today. So I do apologize, but if I drop out again, I'll be gone. So while I'm here, let me just say thank you, Corinna, for the introduction together. I'd also advance thank you to the panelists. I'm very much looking forward to hearing your conversation and discussion today. So I'll be brief. We live in the Anthropocene, an era defined by an unprecedented climate crisis. The crisis is not a natural disaster, even though it involves increasingly frequent and severe and intense events such as floods, landslides, droughts, wildfires, the sort of thing we think of as natural disasters. And it's not a problem that is far off in time or place. The climate crisis is happening now, and it is happening here, and it is happening everywhere. And it is amplifying interrelated global crises such as poverty, environmental pollution, and the loss of biodiversity. Finally, this is not the result of a change in the Earth's tilt, or solar flares, or a meteor crashing into our planet. It is a crisis of our own making. And it is a crisis that was both foreseeable and, in fact, foreseen. The basic science of global climate change has been understood for over a century. President Johnson first called on the US Congress to take action on climate change in 1965, warning of the risk of the very impacts that we are experiencing today. Fossil fuel industry studies from the late 1970s predict with uncanny accuracy the timing and levels of global concentrations of carbon dioxide and the corresponding increases in global average temperatures that we're seeing today. So no one can say that we didn't see this coming. Since the United Nations Framework Convention on Climate Change was signed at the Earth Summit in 1992, it has been the stated goal of the international community to avoid dangerous interference with the climate. At the moment, we are not on course to meet that goal. This is not a matter of it's not just a matter of some widespread failure to take action. It is, to a significant degree, the direct result of affirmative decisions made by governments and industries at multiple levels, many with knowledge of how their decisions will contribute to the increasing risks of climate change. Now, the gap between the greenhouse gas emissions levels consistent with limiting global warming to 1.5 degrees Celsius and our current and projected trajectories, the so-called emissions gap, can also be thought of as a policy gap. And to fill that policy gap, an increasing number of entities, including subnational governments, non-governmental organizations, community groups of different sizes, indigenous peoples, and individuals from global youth to a particular group of elderly Swiss women, are turning to the courts to demand action from the national governments and from corporations. Some other resources, and we look at these cases quite closely, and the plaintiffs and the petitioners in these cases are pressing a wide range of arguments. Some of these cases seek to mainstream climate change considerations into existing laws relating to pollution control, natural resources management, energy and land use, to ensure that climate change factors into decisions across the board. Some of these cases seek to deploy potentially game-changing applications of fundamental rights, of human law, to force recalcitrant governments and corporate actors to take the actions necessary to give society a decent chance of passing along an inhabitable planet to future generations. As we are going to
think Mike has frozen. Perhaps if you turn off your video, it could help, but I think if I'll give it a minute and then carry on. Okay, Mike, sorry about that. We will definitely bring you back in to say what you, to finish what you have to say at the right time. And I will now speak to provide a bit of framing before I introduce in turn each of our speakers. The relationship between ethics and law has been at the crux. Okay, you want to finish, Mike?
Okay, yeah, I was just coming to the end.
Okay.
So, this newly articulated crime that can influence the ways in which governments and industry leaders understand the consequences of their own affirmative decisions, both for themselves and everyone else. And maybe even it can provide some justice on the side. So with that, I'll turn it back to you, Corinna, and I'm very much looking forward to hearing the discussion and conversation from our experts on the panel. Thank you.
Thank you so much, and thank you for all of your great work. The relationship between ethics and law is something I want to say a brief word about before we begin. It has been at the crux of all major breakthroughs for justice. Ethics deals with the difference between right and wrong and the implications for behavior. It undergirds laws and social norms in all societies. But ethics as a field is most powerful when a widely shared and deeply felt sense of right and wrong is out of step with laws and social norms. Think abolitionism, women's suffrage, anti-apartheid movement, and civil rights. In Letter from a Birmingham Jail, Martin Luther King Jr. drew from faith traditions when he appealed to a shared sense of morality that calls us from someplace deeper than contemporary legality and social habituation. And in one of many powerful passages, he wrote, "We must never forget that everything Adolf Hitler did in Germany was legal." It was shortly after the atrocities of the Holocaust that world leaders acted to make sure that they could never be considered legal again. The International Military Tribunal at Nuremberg in 1946 was set up to try leaders of the Nazi regime for war crimes and crimes against humanity. And in 1948, a United Nations convention defined genocide. The experiences of the following decades revealed the need for more structure to deal with such cases, culminating in a diplomatic conference in Rome in 1998. The Rome Statute of the International Criminal Court establishes that court as a permanent institution, seated at The Hague in the Netherlands. It has jurisdiction over, quote, "the most serious crimes of concern to the international community as a whole," end quote, and specifies them as the following four: genocide, crimes against humanity, war crimes, and the crime of aggression. Today, we will hear from people with expertise and experience in international criminal law, human rights, wildlife crime, and environmental law to discuss a proposal to add a fifth crime to the Rome Statute, ecocide. This concept has been talked about for years, including in the various ways that indigenous communities objected to the ecological violence done to their territories in the course of colonization, in response to the horror of the use of Agent Orange in Vietnam, and by Swedish President Olof Palme at the first UN Environment Conference in 1972 in Stockholm. The organized effort to make ecocide an international crime is owed to leaders such as Scottish barrister Polly Higgins, who co-founded Stop Ecocide International with its current chair, Jojo Mehta. At the end of 2020, Stop Ecocide commissioned a panel of independent legal experts from around the world to draft a definition of ecocide. Our first speaker, who I will introduce in a moment, was a deputy co-chair of this panel. As a result of their work, a very real process is in motion. This past December, at the meeting of the ICC at The Hague, there was a side event hosted by the Republic of Vanuatu and the independent state of Samoa, small island nations whose very existence is threatened by man-made climate change, at which the definition was revealed and launched. Next December, any one of the 123 states that are members of the ICC, and we must note that the US is among the powerful countries that is not a member, may propose the draft law as an amendment to the Rome Statute. There is something else at work in this process: the normative force of the concept of ecocide itself. As with other ethically driven movements to change laws, there is a change in perception along the way. The word ecocide asks people to pause and consider that nature is alive. It also puts a point on the question of human agency. It is also worth noting that in 1948, the year of the Universal Declaration of Human Rights, the human population was about 2.4 billion. Today, there are about 7.9 billion people on Earth, and will be 11 to 12 by the end of the century. At the same time, we have seen massive deforestation, depletion of water and topsoil, the beginnings of a wave of mass extinctions, and the perilous filling of our atmosphere with greenhouse gases caused primarily by the burning of fossil fuels. Those who suffer the most from this pattern are those who have done the least to contribute to it, as the recent deaths from extreme weather events demonstrate, including right here in the place I call home, New York City, ancestral land of the Lenape. This ecocide law proposal comes at a time of heightened awareness of the pace and scale of ecological destruction, the reality of who is in harm's way, and the challenge of marshaling the collective will required to stop it. The current ecological crisis is about more than data and technology, as important as they are. It is about our moral obligations to one another across space, time, and even species. So thank you all for being here today for our gathering on Ecocide, a discussion of law and ethics. And now I will introduce our first speaker. Kate McIntosh was co-deputy chair of the expert panel that drafted the legal definition of ecocide. She has worked in the fields of human rights, international criminal justice, and the protection of civilians for 3 decades, including holding multiple roles at international criminal tribunals. And she is now the inaugural executive director of the Promise Institute for Human Rights at the UCLA School of Law. We're so honored that you're with us. Thank you, Kate.
Thank you so much, Corinna, and thank you to Fred and Michael as well for those really interesting introductions, and for Michael for struggling through his internet issues. So I'd like to jump off maybe your beautiful framing, Corinna, about the ethics and the power of the name of ecocide, to talk a little bit, first of all, about why I think it's important, or what the value is of using international criminal law in particular to try to address the destruction of the environment and climate change. So we heard from Michael about the multitude of brilliant, creative legal strategies that are being deployed around the world to try and confront this overwhelming problem we're facing. Most of these are within the framework of civil law or human rights framework, so where the victims call upon those responsible to recompense them for the damage done, or to in some way halt their behaviour. The thing about criminal law in general, which I think is really interesting in this context, is it takes that burden from the victims, right? We assume, as the global community, or as the national community in particular states, with criminal law, we take actions which everyone has decided are beyond the pale, and we hand the responsibility for enforcing that over to our state apparatuses, or to the international criminal law enforcement apparatus. And I think that's really important in the context of something like climate change and environmental destruction, where, as you pointed out, Corinna, we're all affected, of course, we're all victims of climate change, but those who are most affected tend to be those who are the most marginalised and with the least resources. So I think it's particularly fitting to look at how criminal law can play a role. International criminal law, I think, then really hits that point about the moral or expressive value. So naming ecocide and calling the destruction of the environment or climate change an international crime up on the same level as crimes like genocide, crimes against humanity, or the crime of aggression, I think is really powerful and should not be underestimated. And I think that however many actual prosecutions we see of that crime, part of the power of its creation is going to be in the work it does to shift thinking and to change the narrative in the way that you set out. And I think for the kind of massive systemic behavior change that we need to put into operation, something like that could be really valuable. I'm just going to talk, I think, perhaps we could put the slide up and I can just lay the background for this conversation by talking through the proposal that we came up with. So as Corinna laid out, I was part of a wonderful panel of 12 people from around the world who were brought together by the Stop Ecocide Foundation to come up with a definition of ecocide that could be proposed as an amendment to the statute of the International Criminal Court, and so join that statute as the fifth international crime. So there are existing suggestions already for the crime of ecocide. Others have come up with them, but the idea was to craft something that was really in the language of international criminal law and very much in the framework that's grown up around the Rome Statute and the practice of the International Criminal Court. So something that would be really a credible proposal. And that was really our goal, to come up with a proposal that was credible enough to start a serious conversation about this being included in the statute. And I think we've met that goal. And perhaps this webinar is one manifestation of that. But I think this is a serious proposal, and that was really what we aimed to do, to launch the discussion. So if you look at the definition that's just been put up there, so the core definition is in the first paragraph, and in the second paragraph we add some definitions of the terms. But ecocide itself we define then as unlawful or wanton acts committed with knowledge that there's a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. So our guiding principle was really to draw as far as possible on existing international law, and in particular international criminal law concepts, as I've said, in order for it to be taken seriously by states and scholars and academics and the legal community, and to launch this conversation about a real amendment. So I'll pull out a couple of points to note. First of all, I draw your attention to the fact that this is a crime of endangerment. So there is no actual requirement for the damage to take place in the crime. The criminalized behavior is risky behavior. So it's acts committed with knowledge that there's a substantial likelihood of the harm being caused by those acts. And so that mirrors several other crimes in the Rome Statute. Crimes of endangerment already exist, particularly around war crimes, launching attacks and so on. And in fact, in the other crime in the statute, which prohibits causing damage to the environment, because there is already one war crime of causing widespread, long-term and severe damage to the natural environment, but it only applies during armed conflict. So it comes from a very different place. And it's really about preserving one country's environment against attacks from a country with whom they're in conflict. And it's not about the kind of damage that we're talking about now, which of course is not only part of peacetime, but actually, part of our way of life. So, so crime of endangerment, as I said, so that's worth looking at. It's particularly important here as well, because we didn't want, with the state of, and this is based on scientific advice and our understanding on the panel, not that we were scientists, but that proving for environmental damage, proving an absolutely 100% trail of causation, is very difficult, and it might make the crime actually unusable. Proving a very substantial risk of that harm from certain acts is possible. So that seemed to be also the most practical and usable way of crafting the crime. The other two things I wanted to pull out were the thresholds that we've included in the crime. So obviously, in order to be an international crime, the damage has to be of a particular level and of a severity that is on a par with the other crimes in the Rome Statute. So we put two thresholds in our crafting of the crime. The first one was in the description of the damage, which we classified as severe and either widespread or long-term. And those terms, severe, widespread, long-term, are drawn from existing international law, which prohibits damage to the environment, most particularly in time of armed conflict, and reflected in the war crime in the Rome Statute protecting the environment. We shifted it around a little, because in the war crime, the terms are used in a conjunctive way. So it's severe, widespread and long-term damage is required, or that's the damage that's prohibited. It's required in order to fulfill the elements of the crime. We had a long discussion about whether that was the way to go. There's another international legal instrument that uses those terms disjunctively. So either severe or widespread or long-term damage is prohibited by the convention that prohibits hostile modification of the environment. And we talked a lot about which of those paths we should follow, and we finally decided on a third way. We felt that in order to meet the gravity required by the Rome Statute, any damage would have to be severe. So severe was an absolute necessity, but we thought that to require the damage to be both widespread and long-term, again, might exclude some instances of damage which we all felt instinctively should fall under the qualification of ecocide. In particular, being geographically widespread seemed to be too limiting. And severity was a problem in that we thought it might be possible to repair massive environmental damage, with substantial input of resources, but that we wouldn't want that to be a reason for the acts not to be criminalised in the first place. So our solution was to take as our definition that the damage to meet the criteria of ecocide would need to be severe in all cases, and in addition, either widespread or long-term. And another important thing to say about our definitions of the severe in either widespread or long-term damage is that we move away from the anthropocentric approach of the most of the Rome Statute. And this is, of course, a really important element about including the crime of ecocide at all, because environmental damage could already be punished under the Rome Statute if it were to meet the elements of crimes against humanity, genocide, and so on. So we introduced ecocentric elements. So human harm is not required in order to meet the threshold of ecocide. It is not necessary that humans be harmed in order for the crime of ecocide to be committed in our proposal. So if you look at the definition of severe, for example, severe damage is damage which involves very serious adverse changes, disruption, or harm to any element of the environment. So it doesn't require harm to humans in all cases. And if you look at the definition of widespread, you'll see that we talk about the definition being not just extending beyond a limited geographical area, but also damage which is suffered by an entire ecosystem or species, or a large number of human beings. The second element then that I wanted to, or the second threshold I wanted to draw your attention to, and this is the last point I'll make before handing over to the other speakers, and I look forward to the conversation, is that the damage has to be committed through unlawful or wanton acts. So this is building on the structure, the general structure of international criminal law. It tends to be the case that the acts that are prohibited under international criminal law are also unlawful in domestic jurisdictions, for example, although of course that's not the case for the creation of new crimes in the way Arenna expressed in her introduction, because the acts of the Holocaust were legal in Nazi Germany. However, the idea that something's already unlawful is both easier for states to accept and also an easy hurdle for a prosecutor to meet. So if an act is already unlawful at national level, then it's crossed this threshold. And that's important because, as we all know, many of acts of environmental destruction actually are prohibited at national level, and it's more a question of political will and enforcement than legal prohibition. So environmental lawyers will often say, we don't need new law, we need enforcement of existing laws. And this is designed to deal with that situation. So where an act is unlawful and it does risk severe and either widespread or long-term harm, it will meet the definition of ecocide. However, that's clearly not enough, because the other problem is that there are acts which are perfectly lawful and which are contributing to the situation we find ourselves in today. So there we really had to come up with a new standard. And to do that, we drew on existing law in a number of ways. So we've introduced the term wanton. So wanton is a familiar term in international criminal law and international humanitarian law, and in fact already appears in conjunction with the term unlawful in some of the other crimes in the Rome Statute. We've defined it as meaning with reckless disregard for damage which would be clearly excessive in relation to the social and economic benefits anticipated. And what we're truly trying to get at there is we're looking at acts which are committed completely wastefully and without justification. So that's what we're trying to gather in this international crime. And that's not to say that there might be acts which should not go ahead in the interest of the environment, but which are, which don't meet this threshold. But this is really saying that in order to be raised to the level of international crime, if these acts are not already unlawful, they have to be completely out of balance with any social or economic benefit conceived of. And we're also intending there to bring in the idea of sustainable development, the core concept of international environmental law. We thought it was important to have, at least maybe speaking from my own perspective, I thought it was really crucial to have a mechanism via which this international crime could speak to the current regime of international environmental law and climate law, because it seemed that it was a complete non-starter to suggest an international crime which was not able to be in conversation in some way with the entire edifice of regulation that's been built up. And so in my view, the use of this term wanton, its reference to a proportionality requirement in balance with social and economic benefits is a way in which concepts like sustainable development, maybe even common but differentiated responsibilities, could be imported into assessment of this crime. And I'd be really happy to talk about that because I think it's a very complicated, tricky, but in my view, crucial element. Just finally to say that idea of a proportional requirement within the definition is also reflected in other elements of the Road Statute. So the existing international crime, war crime of causing damage to the environment also has a proportionality test. So again, we imported something from international environmental law. We use language and a structure that comes from international criminal law, and we hope via that means to make it understandable and acceptable to the states and international lawyers who will be thinking about actually adopting this into the statute. So I'll leave it there and look forward to hearing from the other panelists.
Thank you so much, Kate. I just wanted to follow up quickly with a couple of questions. It's so interesting to hear you talk about how you all discerned those particular words and the definition in general. And I was wondering, in the case of wanton, it's interesting that it says wanton is reckless disregard for damage which would be clearly excessive in relation to social and economic benefits anticipated. So going back to the point that you raised, that there are activities that are actually perfectly legal now that are nonetheless drivers of massive ecological destruction. I'm wondering, this definition of wanton, the mention of social and economic benefits anticipated, seems to acknowledge that some of this is done in the name of development, economic development, even if it does not end up benefiting most people. So I'm wondering if the panel discussed or interrogated the common ways in which people measure social and economic benefits in their thinking about this definition.
Yeah, that's a great question, and we did talk about that a lot. I mean, at the end of the day, it's impossible in a proposal for a crime to determine how that's going to be interpreted by judges in the courtroom. All we can do is provide a framework which we think allows for the relevant elements to be taken into account. And of course, the question is, how do you balance social and economic benefits? Whose voices are heard in that conversation? One criticism would be, does that mean that if it's offering any economic benefit at all, then it would be justified? And of course, that was not our vision. But we did come from a place of thinking, well, we have to be able to argue to states how this makes sense. And I think it was also a learning process for many of us that came from the international criminal law background, which I'd include myself, because I assumed initially that an international crime of ecocide would involve finding out what was prohibited in international environmental law and then saying this plus very, very bad equals an international crime. And, I discovered that virtually nothing is prohibited in international environmental law. Like, that's not the way it works. It's not like criminal law. It's all about process and consultation, and it's really at national level that those environmental standards are set, and that those are set by weighing, these three elements in particular. So for us, it was important to say, or to understand and to convey a method within the law for judges to take those considerations into account, and to think, well, there may be developments which are really necessary and beneficial, whether those are transport links or desperately needed housing, which will without a doubt cause some environmental destruction. They might even fall into the definition of severe and long-term destruction to the environment, for example. And they might also be campaigned against and not wished for, but are they really an international crime? Is that what we're looking to criminalize here? And would that be acceptable? And we felt we had to put in a mechanism which explained that we're not about that. This isn't something which is, going to easily block a new road. I mean, at least in a way that's where in a neat area where it's really needed. That it might be that road shouldn't be built, but that will be dealt with in different ways. We're talking about an international crime. We're having to talk about something that's on the same level as genocide. So it has to be completely out of balance with any of those benefits. So that's really what we're trying to capture there. We felt there had to be a place to have that conversation in the crime. Now, where the balance is drawn, it's kind of impossible for us to set that up in the drafting, but that was our vision, and we hope that it's drawn in the right place.
Thank you so much. I just have one other quick follow-up for you, and that is, I just want people who are listening who may have missed it to know that that there have been some moves made to petition the International Criminal Court on internal criminal investigations regarding acts under crimes against humanity that might otherwise fall into the definition of ecocide. And in particular, I'm thinking of a couple of actions, a couple of these petitions that came about in the past couple of years about Brazil. And in the year 2020, the deforestation rate in Brazil rose 25%. And many people point out that the effects of deforestation in the Amazon, which we hear about as the lungs of the planet, does affect people worldwide. So I wondered if you're able to comment on how that process has gone in terms of petitioning for an investigation of the president of Brazil based on crimes against humanity has influenced the discussion around ecocide.
I think the main relationship, so first of all, I think there have been many communications, indeed, that notably about Brazil. There have also been communications to the prosecutor about other situations. I know Cambodia and the palm oil plantation and associated deportation or forcible transfer of civilians was also a communication that got quite a lot of attention. I think, as I said, it is of course possible for environmental destruction to be prosecuted at the International Criminal Court if it's a means of committing one of the existing crimes. So I think genocide has been alleged in connection with Brazil around the indigenous people whose lives are being so drastically affected by what's happening in the Amazon, for example. Crimes against humanity has been framed. The definition of crimes against humanity is that it's a widespread or systematic attack on a civilian population. And I think it is possible to see certain acts of environmental destruction in that framework, but not all of them. And obviously it's a hugely anthropocentric, a totally anthropocentric definition. So it's not just a requirement of human harm, it's a requirement to prove an attack on a civilian population. So that limits the scope for using existing crimes in the statute. And I think one motivation of these communications to the International Criminal Court, I mean, one is, of course, to publicize what's going on and to try to stop it. But I think a side motivation has been to highlight the limitations of the existing law and really to call upon the public conscience to say, look what's happening. Surely this should be an international crime. Actually, under current existing international law, we could only really charge, this part of it, because there's a whole swathe of those activities that cannot be characterized as genocide, that cannot be characterized as crimes against humanity. So actually, these communications serve to highlight that there is a gap in international criminal law, and that where we're thinking about protection of the environment, especially if we dissociate it from immediate impact on humans, we don't have any tools. And so in a way, it highlights the importance for us to bring in this new fifth crime of ecocide.
Thank you so much. Very interesting. And now for our next speaker, I am delighted to introduce Olivia Swart-Goldman. Olivia is the executive director of the Wildlife Justice Commission. She's over 25 years experience in international criminal law, international humanitarian law, and diplomacy, including serving as head of the International Relations Task Force of the Prosecutor of the International Criminal Court and legal assistant at the UN International Criminal Tribunal for the former Yugoslavia. You can see her full bio in the chat. I want to also mention she is joining us from The Hague, where she lives and works on fighting wildlife crime. Olivia.
Terrific. Thank you so much, Karina. And thanks to all the co-hosts for convening this really, I think, incredibly interesting and important conversation. So thank you for including the Wildlife Justice Commission as well. I think it's really exciting for us to be here. I wanted to build on the framing remarks and on Kate's really comprehensive discussion of the elements of the crime, and talk about three things. So the first is the chances of prosecution for ecocide at the ICC. The second is how it could possibly be applied to a case, for example, a case of wildlife crime, and then look at the potential advantages for applying the issue of ecocide to wildlife crime. And I know we've got a really limited time, and I'm very ambitious in what I've set out. So I'm just going to touch upon these topics, and I'm sure there's much more depth that we could go into, but I'm just going to sketch these issues. So starting with the chances of prosecution, now obviously, in order to be prosecuted at the ICC, it needs to enter into force in the Rome Statute. There are prospects for this. There's support from states is increasing. Karina, you mentioned Vanuatu, and also the Maldives is a real champion. Belgium, France, and the EU are keen and have strong political mandate, which is very important. There's support from Bangladesh, Samoa, Chile, and Finland, and Canada and Luxembourg have voiced interest. So basically on a crescendo of interest. But what's really important is this is a treaty. So you need states to be pushing it, to be encouraging it, to be getting other states on board. So the fact that this group of states that's interested is growing can be really important in facilitating more states to join the bandwagon until you have enough where you think there's a real chance of success. So that's really important. It's a long process, but it's taking shape. And certainly, if you'd asked me 10 years ago if this was viable, I would have said not in my lifetime. And it is, I think, incredible. And I think it's in large part also to the great work that the Stop Ecocide Foundation has done and getting such a phenomenal panel together to put together a definition that's really, it makes sense. It fits within the framework. It's not some like wacky, like, oh, let's do this. It's like, okay, this is how it would actually be. So I think, compliments to everybody involved with that. I think it's been tremendously helpful in moving this process along. If it is included in the Rome Statute, the question would be who or what should be prosecuted. I think most people know the Rome Statute has a mandate to prosecute individuals. It's individual criminal responsibility. Companies do not fall within that, but obviously companies are owned, operated, and managed by individuals. So that's one thing to be taken into consideration when looking at the potential for prosecution. Now, the proposed definition that Kate highlighted, it excludes listing a specific list, and then there's very good reasons why they decided to do that. But it could cover a variety of crimes that some of which could be quite difficult to prosecute. But I just wanted to note, and I think Hugo's going to talk about this as well. One of the great advantages of including it in the Rome Statute, if it gets that far, is that this will strongly encourage national governments to incorporate it into their national legislation so that they can then investigate and prosecute these cases rather than the ICC under the complementarity regime. So it'll have a real ripple effect on a domestic front as well. So that would also be terrific. But for the concept of ecocide to be included domestically or internationally, it has to be seen as relevant, and it also needs to have it needs to get some momentum, get some successes. So it needs to start with a case or two to see if it would work. And one of the cases that could possibly be thought about is applying it to the issue of wildlife crime. Now, in order to talk about that, I'm going to talk about three things. That is, what is wildlife crime? Because certainly before I moved over to the Wildlife Justice Commission from the International Criminal Court, I had no idea that wildlife crime was the problem that it is. So I think it's important that people understand the context. Looking at the ecocide thresholds and applications. So could it possibly meet the requirements that have been proposed in the definition, and some international and domestic law aspects. So what is wildlife crime? It's a very broad term concerning the trafficking of endangered fauna and flora. So that includes terrestrial beings, the rhino. It includes turtles and tortoises that are endangered. It includes illegal logging and illegal fishing. So it's really broad. It's the fourth largest transnational organized crime. So it's worth approximately $7 to $23 billion per year. It has a huge impact on economies. When you look at wildlife crime together with illegal logging and illegal fishing, the World Bank has estimated that the economic consequences are up to $1 to $2 trillion per year. So it's just huge amounts of devastation and loss that's come from this crime. Now, wildlife crime has a direct impact on the environment and an indirect impact on humans. So in terms of the environment, it's linked to biodiversity loss. And the EPES report last year already came out with a finding that we're at risk of losing almost 1 million species in the next 10 years. And wildlife crime is a significant contributor to that. So there's a real link to biodiversity loss. It also contributes to climate change through its effect on ocean populations and ecosystems. So that's pretty clear. It also affects humans in terms of human health. Think of zoonotic diseases, risk to security, economies we already talked about, and also it's incredibly linked to corruption and tax evasion and money laundering. So there's a real link to both the environment and to humans. And just to put it in numbers, so every 8 hours, a rhino is killed for its horn. Every 30 minutes, an elephant is killed for its ivory tusk. And every 5 seconds, a shark is killed for its fin. And just to make it clear, there are only 3,500 tigers left in the wild. So we are really decimating our biodiversity and the species. And we're going to end up if we don't do something different, we're going to end up in a world where our kids and grandkids and future generations aren't able to enjoy the wildlife that we've been able to. So there's a real risk of irreparable harm. And that leads me nicely to ecocide thresholds and its application to wildlife crime. So looking at the first one that Kate so eloquently sketched out, is severe and either widespread or long-term damage to the environment. Wildlife crime endangers the stability of ecosystems and risks permanent loss of species, right? We've just talked about that, like how this huge risk is coming and it's happening day by day, and we need to do something to stop it. And also the acts of the top level criminals lead to severe and long-term damage. And again, this is really key. To the extent wildlife crime has been addressed, traditionally it's been focused on the low-level offenders, because that's not easier to do, but it's much more available. Whereas what we need to be doing is to be going after those top-level criminals, those facilitating and orchestrating the crimes, and that's what we do at the Wildlife Justice Commission. But really, it's the top-level criminals that are really having this impact of severe and widespread damage. They're the ones orchestrating just massive amounts of wildlife crime. And the second is the proof of the acts are unlawful or wanton. Now, this is, this is a really challenging issue, right? The illegality of international environmental law. But wildlife crime is a little bit like, it's a good place to start in a way, because you have the CITES Convention, which is a convention that regulates trade in endangered species. So it's a trade convention, but it's, for an environmental convention, has a little bit of teeth. So it protects certain species, and the level of protection is connected to the level of endangerment of the species. So the most endangered species, you're for the most part prohibited from trading in. There are some exceptions, but very limited. And then you have, different appendixes below that. But so there is already this idea of stopping the trade, and one of the obligations of the parties to the CITES Convention is not only to prohibit the trade themselves, but to ensure enforcement of the convention, and and that will include penalization. So it'll include penal law elements of criminal law. So that's really important. And importantly, it's also relevant is the UN Convention on Transnational Organized Crime, the UNTOC. So that deals with all kinds of transnational organized crime, and wildlife crime has been recognized under the UNTOC as transnational organized crime. So state parties to that are obligated to take steps to jointly counter this crime, wildlife crime, as well as any of the others. And many states have already incorporated the CITES annexes into their national legislation, including criminal penalties as well as the UNTOC provisions. So there's a framework there in the criminal law realm, which is, I think, incredibly useful as we start to think about how this could work. And just if we wanted to look at wanton, it certainly meets the definition of wanton in that the value derived from trafficking in endangered species for profit is highly outweighed by the danger to the ecosystems that it causes. So there's no balance there. And again, focusing on the high level traffickers, those are decimating our species for profit. Turning to the international and national issues, again, this is where it gets a little bit complicated in terms of reconciling international criminal law, which is my background as well, and international environmental law. But as I mentioned, the good news is there already is some kind of, the wildlife crime already exists in the criminal law realm. So it makes it a little bit easier, and it could be a good starting point for Ecocide to think about applying it in that regard. So finally, just to look at, why would we want to do this? What would there be advantages for moving the Ecocide project further, and would there be advantages for wildlife crime as well? In terms of advantages for Ecocide, yeah, it would make a good test case. As I mentioned, a lot of states have already wildlife crime in their domestic law, so there's a fertile soil. They're already thinking about it. They're already attuned to it. And also individuals commit wildlife crime. So it makes it slightly easier to prosecute than if you have to go through a corporation or something like that. And the advantages for wildlife crime, to see it through an Ecocide prism, are it could be useful for the international recognition of the devastation caused by wildlife crime. It's a really under illuminated crime. As I mentioned, 4th largest transnational organized crime, and I had no idea before I stepped into this. So applying Ecocide to it could really help with bringing the spotlight to it. It could also stimulate efforts to prosecute those most responsible for these crimes. Again, moving away from the poachers, let's focus on those that are really causing the damage. And finally, it could help focus some of the resources and prioritization to these crimes that have been lacking. That's a real issue with enforcement is, a lot of governments don't consider it a priority, so they're not devoting the resources that they could be, and there's the political will to apply those resources and prioritization be lacking, and this could help with that. So while there are also some challenges to applying the concept of Ecocide to wildlife crime, it could be an interesting first test case, and there could be benefits to both sides. So I'll leave it at that. Thank you.
Thank you so much, Olivia. It really is, you have such powerful insights from having spent a career in international criminal law and humanitarian work, and then making that change to focus on wildlife justice. And I wanted to ask you in particular, because I know a lot of your work focuses on traffickers, the transnational criminal networks that are trafficking species, but you've also mentioned that illegal logging and so on result in harm to species. That's also part of your work. So I'm wondering if you could clarify whether that kind of damage to the habitat of wildlife could come into this definition and prosecution of ecocide.
Well, I mean, I guess it depends on the scale and all of that, right? That would be really important. But certainly, like, there is, IUU fishing and illegal fishing and illegal logging have tremendous consequences on the environment. And that is something that's much broader than just the specific of that one individual. So, I mean, I haven't thought about it very carefully, but I wouldn't see necessarily why not, if you could get up to the severity issue of the Rome Statute, and if you could make sure that the other elements were met. But certainly, I mean, the consequences are tremendous, so it could potentially fall within it.
Excellent. And you do, I know Wildlife Justice does investigations of these networks and systems behind the decimation of the vulnerable species. Is there anything you've learned through the process of that work that sheds light on how an effective investigation of ecocide might proceed?
Well, what's really important is, and I think Kate touched on this when she said, environmental lawyers are often saying we have the laws, we just need to apply them. Enforcement is absolutely critical. And that's what this process is also really useful, because it's building political will, it's getting attention to these issues. And we've got a lot of tools and techniques to investigate massive crime. We know how to do it. The question is, are we doing it? And are we using all those tools and techniques? So, for example, we know how to do a top-notch drug investigation with using controlled deliveries, advanced investigative techniques, doing a financial investigation, investigating the whole network. And what we saw was that there aren't necessarily, people aren't applying that to these types of issues. Governments aren't doing it in a way that they could. So we need to stimulate them. There is tremendous opportunity to bring down these criminal networks and others that are committing these crimes, if we do it in a really sustained and consolidated way, using the tools and techniques that we know exist to fight other forms of organized crime.
Thank you so much. Very interesting. And now turning to our next speaker. Hugo Echeverria is an attorney and law professor in Quito, Ecuador, with extensive experience in environmental law, environmental criminal law, and constitutional law. He's an expert with the United Nations Harmony with Nature program and co-president of the research group on rights of nature of the International Association of Constitutional Law. He also lived in the Galapagos Islands for 5 years, working on legal issues from the perspective of World Natural Heritage Sites. His current focus is on a comparative approach to constitutional environmental rights, rights of nature, and protected areas of international importance, including marine protected areas. Thank you so much for being with us, Hugo.
Thank you, Karina, and thank you as well to the co-hosts. It is very nice to be here. If you may share the presentation, please. I will address this topic that has already been raised, which relates to the ecocentric approach to the law. And next, please. And specifically, I would like to share the case of Ecuador, my country, as a unique case of moving towards an ecocentric approach to the law with somewhat positive results in only 10 years. But before that, I would like to continue a little bit with what Olivia has mentioned, and also as well as Kate, and to share these three main ideas. First of all, the proposal on ecocide as a crime in the context of the Rome Statute clearly reflects different concerns, from the climate crisis to harm to nature. So the concept of ecocide is comprehensive. Secondly, I agree with what Olivia has said regarding the concept of wildlife crime. It might be a good place to start, clearly. And there is an issue, a terrible issue regarding loss of biodiversity and loss of species specifically. And we can learn from experiences of enforcing wildlife crime, which is indeed a form of domestic ecocide, a form of national ecocide. And this third idea is important. Wildlife crime is already included in the law of many countries in different parts of the world. So there is some experience that we can learn from. Next slide, please. This is one example. This case, some of you might have heard. This is a case that took place in 2017. The photo shows a vessel of large dimension. This vessel belongs to a well-known international fishing fleet that moves around in the high seas almost year long. Okay, this particular vessel, for reasons that are unknown, was navigating on the high seas, but entered the waters of Ecuador and transported 6,000 sharks that were caught in the high seas. Given that the law of Ecuador considers transportation of protected species as a wildlife crime, this case was prosecuted in Ecuador, and there was a conviction verdict, which was effectively enforced. So I wanted to share this case that if you type shark case in Galapagos, you will find much information on this case. This case, the verdict referred to as a case regarding harm to nature. So with this case, I just want to show you an example of enforcement regarding the wildlife crime. That, as Olivia has said, it is an international matter. It is actually is the fourth largest crime of transnational connotation. The last part is important. Thank you. The last part is important. This case in Ecuador was prosecuted under the logic of rights of nature. Okay, and this leads me to this idea that I want to put forward. What if nature have rights? This is a question that has been around the legal debate, the ecological debate, the social debate for years. And it actually became a reality in Ecuador. And on the second part of the presentation, I will address what has happened with this. But before we enter into that, I will just like to highlight that this is a current debate in different legal systems. We are now, lawyers are now talking about what if nature have rights, not only in Ecuador, but in the world. To the point that at the moment, there are several models taking place. So you have jurisprudence models, like the Colombian case. You have legislation models in several countries, and you have constitutional models, the case of Ecuador. These models all have a common place, a common denominator, that we are addressing an ecocentric approach to the law. And this is new because we all know that the law is based upon an anthropocentric approach. So this is something new. This is something that we are all learning while we go through. And this is why the case of Ecuador is important, because we have begin applying this in practical cases. Just a little facts in order to understand the scope the importance of recognizing rights to nature. Ecuador is one of the few countries holding very high biodiversity rates in the territory. It's only one of 17 countries labeled as mega diverse. Secondly, and this is very important, there is a historical constitutional value on environmental matters. The Constitution of Ecuador recognized the human right to a healthy environment back in the 80s. As a third point, important, very important, Ecuador is a pluralistic society, and because of that, it includes very seriously values of the indigenous community, ethical and moral values from the indigenous communities. And last but not least, Ecuador follows a civil law tradition. The legal system is affiliated to the civil law tradition. Next slide, please. In 2008, the Constitution of Ecuador changed, and among those changes, it actually recognized constitutional rights to nature. So since 2008, nature is a new rights holder. It's a new subject of rights. And this is, as you can see, this is a change of paradigmatic consequences. And I wanted to share why, why Ecuador decided to move towards a different approach. There are many, many reasons, but because of the time, I just want to emphasize on three. Environmental rights, unfortunately, were not as effective in practice. And if some of you are working on the field of environmental law, you will relate to this idea of poor effectiveness or poor enforcement of environmental rights and environmental legislation. Secondly, indigenous values are very important in Ecuador. Therefore, the concept of rights to nature is closely related to the concept of sumac causae, or an idea of well-being in connection with Mother Earth, with Pachamama. And this third point is very important. If you place this topic in the constitution of the country, which is the most important rule of the country, you have access to constitutional remedies that in practice are very effective, as in contrast to environmental remedies that are not as effective. So by recognizing rights to nature, you access to the wonderful world of constitutional law and constitutional remedies. What rights? This is very complicated, but I will just like to summarize in that nature is recognized to have a right of respect, the right of resilience, and the right of restoration. Okay? Now, this is very nice in theory, but how do we put these new rights into practice? Which, by the way, this new concept has been already addressed by the Inter-American Court on Human Rights. This court has labeled these new rights as a trend. So this is something that came to stay. So this is not going to disappear. On the other hand, this is going to be built upon within the years. Next slide, please. Well, 10 years later, more or less, the Constitutional Court of the country, which is the top court, is like the Supreme Court, the most important court, judicial body of the country, issued first verdicts on the enforcement of these new rights. And I want to share these three main ideas, not the only ones, but these three main ideas are important. The court has already said that because these rights are recognized by the Constitution, they are of equal significance to other constitutional rights, such as the right of life, the right of health, the right of freedom. So this idea of having equal importance is very important message that the Constitutional Court has already sent in 2021, last year. Secondly, that as any constitutional right, the state has the duty to safeguard nature, not the environment, but nature herself. And third, because these are constitutional rights to nature, a new subject, a new right holder, new standards should apply. Highest possible standards, more or better than the ones applied by environmental law. Why? Because there is a difference between protecting something, the environment, and respecting the intrinsic value of nature as a new rights holder. So this is language from the 1982 World Charter for Nature, a resolution coming from the General Assembly of the United Nations. So this is international law landing into a constitutional law verdict in one country. This is really interesting from an international law perspective. Next slide, please. And just to conclude, in the same year, and these ideas come from 4 verdicts. 2 of them I just want to lay the general information. The first one, Los Cedros case, is a very famous case that if you, again, look into information in the internet, you will find much information. Los Cedros case is about preventing the extinction. The court ruled in favor of endangered species in September last year. In order to prevent the extinction of endangered species living in a forest named Los Cedros, the court ordered the prohibited mining activities already taking place in their habitat. But the mining activities are not any activity. These were activities authorized by the state under environmental standards and involving important mining corporations, transnational ones including. So the court was very applied the Constitution and said that if the Constitution recognizes rights to nature, preventive measures should take place in order to avoid the extinction of endangered species that are living in the habitat, and that therefore these activities are not in accordance with the constitutional values set by the Ecuadorian Constitution. Next slide, please. Just to conclude, and this is the last slide, why is this important for Ecocide in the context of the Rome Statute changes? First of all, important to recall that Ecocide is a concept included in the law of many countries. The notion of Ecocide is there. The relationship with nature right now is already being reviewed from different approaches, including an ecocentric approach. This is really, really important. The third idea is that I cordially invite you to study the case of Ecuador. This is a unique constitutional model to date that has been put into practice with some positive results. In 10 years, we have done what rights of nature has done what environmental law has not been able to do in 40 years of existence in this particular country. And Ecocide might benefit from an ecocentric approach in the dialogue, in the debate within the changes of the Rome Statute. And finally, that this is a challenging matter. This is really a challenging matter. This is very difficult, complex situation. But I think we all agree that the time is right for Ecocide to be included in the Rome Statute. Thank you very much. I welcome any questions.
Thank you so much, Hugo. That's fascinating. And we're so fortunate to have your perspective on the cutting edge of right of nature law in Ecuador. I have a quick follow-up question about you very clearly pointed out what rights you're talking about. And it includes resilience and regeneration, as I recall. I'm wondering if you could say a word about the role that science plays in understanding whether or not those rights are being violated.
In all these cases, but particularly in Los Cedros case, the one that I mentioned as being globally important, science plays a fundamental role. The decision of the court is 100% founded upon what science said. And this was reflected in a public hearing that the court held and received 21 scientists from all over the world explaining the biodiversity living within these particular protected forests. So therefore, the experience shows that when a judicial decision is based upon science, the reasoning of the decision is accurate. To conclude, science is very important when deciding on cases regarding harm to nature or, for that matter, damage to the environment.
Thank you. That's so interesting, and we can certainly think about how science will be very important in any prosecution of ecocide. And I want to now turn to the full panel. In the interest of time, we have 15 more minutes. And I'm just so honored that you all are with us and fascinated by what each of you has shared. One of the things I find about lawyers and legal thinking is that there's a great discipline of understanding the strongest arguments on the other side of whatever case you're arguing. And all three of you are in support of an ecocide law. But I wonder if you could say a word about the strongest arguments that you've heard or challenges that you've heard on the other side. And in particular, if I might offer one that I've heard, it would be that somehow human rights might suffer from a shift in focus to the ecocentric approach. So that's my question for whoever wants to lead off.
I'm happy to jump in, and I'd love to hear what the others have to say about it. So I actually haven't heard that reaction. I think that's a really interesting one. I actually just led a class where the students were trying to solve the challenge of California wildfires through international human rights law. And it was like intensive 2 weeks thing. And one of the potential avenues that emerged, which they didn't follow in the end, was that international human rights law needs to be reformed because it's too anthropocentric. So, which I love that as a reframing of the whole problem. But I do think that, I mean, just very briefly, I think we are at a point where understanding protection of the environment is so intertwined with understanding human rights, right? I mean, people have understood that for a long time, but I think there have been quite separate movements around human rights and the protection of the environment. And they're being brought together, of course, at the UN, and all the resolutions around human rights and the environment, the exciting developments last October, the different cases that Michael outlined in his introduction as well. So I think the only way forward is, a modification maybe of both visions and a real understanding of the kind of position that I think Hugo was talking about, with that sort of integration and understanding ourselves as part of an interrelated system. And for me, the ecocentric, anthropocentric dichotomy doesn't really make sense. I think something can be more along one side or the other of the scale, but we do not exist in isolation, and neither does nature. So, I would see the two as influencing each other.
Thank you. Others? Hugo.
Yes, actually, this is actually an argument that important jurists raised against rights of nature in Ecuador. This is important to say. The rights of nature in Ecuador are not necessarily welcomed by everybody. So this is a constant judicial battle that to actually put these new rights into practice. Those who are against rights of nature argue that these new rights weaken or debilitate human rights. But the reality is showing exactly the opposite. Rights of nature do not weaken human rights, but actually complement human rights, because we are also part of nature. And if we destroy nature, we are also destroying ourselves. And in a more practical matter, what rights of nature are saying is that the standards should be better. That we should be doing better in terms of better relating ourselves to nature. Okay, so in a way, what rights of nature are, the message they are sending is that the concept of sustainable development should really be put into place. And you all know that the concept of sustainable development means, development plus protecting the environment plus respecting the values of society.
Thank you, Olivia.
Yeah, just to jump in, and it's a great question, Corinna, and it's, lawyers love stuff like this. So, really, I think that the challenge has been the thinking of, okay, on the one hand, we should protect nature because it's important for us, right? And again, that's looking at it from a human perspective, to moving to we should protect nature or the environment because it's right to do so. We have no authority to be destroying it the way we have, and looking at it from that perspective, as opposed to because it's it's better for us as humans to it. And I think the concern is, if we do that, if we move away from this human-centric, then where does it end? So if we're talking about, nature having rights all in itself, does that mean then, does it go to animals that have their own rights and should be able to litigate in court and the rest? So I think there's a concern that if we move away from protecting the environment because it's important for people to protecting the environment because it's important per se, that there's a question of sort of the breaking the dam. Where will we end up if we really shift that paradigm?
Thank you so much. I'm going to turn to a couple of questions from the chat, but while I do that, I want to also ask each of you to think about whether you have a question that you'd like to ask of a fellow panelist, because I don't want to waste the expertise and experience here, and I'd love to hear what questions you all have of each other. So I don't want to waste the opportunity to take advantage of the expertise and experience, I should say. One question in the chat is regarding national borders, and what will that create a problem here in the prosecution of ecocide? Of course, we all know one of the elements of nature is that it with COVID, as with climate and many other things, pays no attention to man-made national borders, but law does. And so I think it's a great question. Can someone speak to how this comes up in the topic of ecocide?
I'm happy to. I think that actually, it's a great question. I think that that's one of the advantages actually of the international criminal law framework. There are all sorts of interesting jurisdictional questions about where these crimes occur, right? So obviously, and there are theories about that. Is it where the effects are felt? Is it where the one of the initial causational acts was committed? Where are these crimes committed? And I think that potentially that actually opens up a lot more possibilities for jurisdiction for the courts. So you may find that's part of the crime is committed in a state, for example, which isn't party, but another part of it is committed in a state which is party. And we've seen that the court, in those circumstances, is open to considering that it would have jurisdiction over the crime.
Thank you. And now I do want to open it. Does one of you have a question for another panelist on your mind? Okay. Olivia.
No, I was just curious, Hugo, because you have such a such experience. Can you tell us how did it happen that Ecuador could develop this really progressive view? What was the background to it? I know you touched about it in your presentation, but I'd just love to hear a little more, because it could be such an example for others.
Yes. A combination of reasons again, but I guess the country has had very negative experiences regarding environmental damage in the past, specifically regarding the oil industry. So I guess that was an awakening call to profoundly, to seriously debate on what is the role of law regarding the relationship between human beings and nature, beyond the logic of protecting the environment as something surrounding us. If you add this reality to the pluralistic values that are important in the society, including indigenous values, then you have, and if you have a momentum which was important in early 21st century, making changes into the constitution. So the momentum was the right time. It is the same as I see with Ecocide being or trying to be included in the Rome Statute. The momentum is important. And 10 years later, again, this is a new idea, as just like any new idea is not free from controversy and debate, but it's coming out very nicely. It's showing that this idea that was not welcomed by all, by some, it actually makes sense if you address it very seriously. So I guess this is what I can share. Of course, we can go beyond what I have mentioned. There are other reasons, but these are the main arguments.
Thank you so much. We have only a few more minutes and so many good questions. So I'm going to try to pull out two more, and then I'll close this at 1:30. One person asked, how should corporate boardrooms seek to address the issue of ecocide? Is there a way that this can come up now, even before it becomes added as a crime?
I mean, thank you for that brilliant question. That would be absolutely what we would hope for, that this conversation about ecocide becoming an international crime already feeds into the risk analysis of corporate boardrooms, and that they see it as something coming down the track. We even had one proposal we discussed in the group at one point, whether there should be a sort of delayed implementation of the law, which is something that could still be built in, of course, by the states who discuss it, precisely in order to give corporations and states times to kind of get their ducks in a row, because of course the objective of this law is not to have loads of people hauled up in front of judges, but to change behavior. So I would hope that ecocide would be, and I think this is one of the powers of it actually, is its potential to affect corporate decision making, because I think that's decision making which is far more likely to be affected by the potential reputational risk, as well as potential risk of actually going to prison, of course, for the individuals concerned, than we might imagine political leaders being affected by the risk of prosecution at the International Criminal Court. So yeah, I would think that the potential for changing risk analysis in the boardroom is high.
Thank you so much. One other question I'm going to combine two. Someone asked about the daily actions that cumulatively add up to severe damage, and another person had asked about whether ecocide might apply to plastic pollution, which of course is a massive problem on a massive scale that's traced back to those daily cumulative actions. Any thoughts on how to answer those questions, how one thinks about that under the rubric of ecocide?
I would say I would say that cumulative actions will enter into the concept of ecocide. This, and you know, if you see existing environmental law, the concept of accumulative actions belongs within the framework of environmental harm. So I will say yes.
Yeah, I would just echo that. I won't touch on the plastics, but if you think about sort of wildlife trafficking, for example, and you know, 500 tons of ivory here, and you know, it's the cumulative amount, the impact that it's having. It's devastating. It doesn't have to come all at once. It can be built over a period of time. So I think it would definitely fit within the concept more generally.
And on the level of cause, of course, you know, there are many people that are using fossil fuels. There are many people that are using plastics, but there may be a case where there's could it apply to an individual that authorizes a massive new source of such pollution? Kate.
Yeah, I think we'd have to find, I mean, I think we would not be looking at criminalizing everyday behavior. I mean, definitely changing that behavior, but I don't think we would imagine that as individuals who drive cars and take flights on planes, that we would be likely to be hauled up in front, because I think probably our acts are unlikely to alone be able to, you know, be said that there's a substantial likelihood of them causing severe and either widespread or long-term damage. It's this issue of the systemic nature of the crime, right? And I would point out that it's not the only systemic crime that's provided for in the Rome Statute. And we did look, for example, at the crime of apartheid, which is included in crimes against humanity. And you might think in a similar way, who within the system of apartheid, which of course was practiced in an entire society, or is practiced in the entire society, who would be actually liable for an international crime of apartheid? And I think it's similar. It's those with the most responsibility, those whose decisions or actions or omissions are able to create, you know, really this severe and either widespread or long-term impact, who would be at risk of prosecution.
Well, thank you all so much. We are out of time. I'm so grateful to each of you for being with us and sharing. I'll just close by saying that the current ecological crisis has many ethical dimensions to it. In looking at the concurrent crises in climate, biodiversity loss, and human health, we can see that there is a root cause which has to do with ethics. We can no longer afford to perceive the earth as an inanimate set of resources to be dominated, or to look the other way when powerful actors devastate huge swaths of it. There is no new technology that will make us do that, but there is a great force in human wisdom, ingenuity, and moral courage. And we've heard a great deal of that here today. So I want to say thank you again to all of you, and thanks to everyone in attendance.
Thank you so much, Karina.
Thank you.
Thank you.